Hi, I'm Will Howard, and this is the third part of a series of 4 about the courts in Talbot County. Today we're going to talk about the court that is the least understood by the people of Maryland, of the whole country. I guess that's because of the name. The name is still the old name from back in the old days of London, the Orphans Court of Talbot County. And we're going to talk to Judge Don Duncan today. Don has been a judge for, what,
5 years.
5 years now.
How are you, Will?
Good to see you.
Good seeing you.
Tell us about the history of the Orphans Court.
The Orphans Court goes all the way back to King Henry VIII.
Wow, that's a long way back.
That's a long ways back. It was founded in the old city of London and was designated a Widows and Orphans Court. That court was established to protect the assets because at that time only males could own property.
Now, we're talking about the time of the bubonic plague and when there were lots of orphans, and orphans and women could not own property.
They could not own property, only males could own property.
So that's the reason for the name.
That's the reason for the name, and they were to protect the assets. When a male property owner died, his assets almost stayed in limbo until the heirs grew up, and it would only go to a male heir. Those assets needed to be managed and protected. So the court was established and set up with 3 judges, men of judgment and integrity, businessmen, to maintain the assets, to not let them decrease and hopefully grow them, and protect them for the heir when they became of age. That court, during the colony days, was moved over to the United States as the colonies were developed. Land grants were given. People like Lord Baltimore were given land grants. They brought the judicial system with them. In addition, they brought the Orphans Court. That court, again, was set up basically as 3 lay judges, men of integrity and judgment, who would protect the assets of the decedent. In the state of Maryland, the decedent is required, if he owns or she owns property, to file with the Register of Will, and we'll go into that later on when we talk about duties. But the Orphans Court, interestingly enough, and this is a relatively new thing most people don't understand, is there's only 2 states left in the United States that are referred to as Orphans Court. That's Maryland and Pennsylvania. Every other court in the United States is either family court, probate court, or surrogate court. So we have retained it since our heritage days.
They even tried the last election to change the name.
Yes, they have tried numerous times, but it has not changed. During the Revolution and when the first Maryland General Assembly was established, they continued with the court, 3 judges, men of integrity and judgment, to oversee the assets and protect the widows and orphans. In the 1851 constitutional amendments, the Orphans Court judges were constitutionalized, and the Constitution required that they be elected every 4 years, along with a Register of Wills, who is elected every 4 years, that they be either laymen or lawyers. They could be either one, but not required, and that they would run for office each time and let the public, because it is a people's court, elect them to office.
I know throughout the state of Maryland, the majority of judges are in the Orphans Court are lay judges.
That is correct. About 2/3 of the courts and the constitutional law required that every county and the City of Baltimore have a panel of 3 judges in the Orphans Court. 2/3 of those are lay judges, and 1/3 are attorneys.
Point out to me where the courtroom is. I guess we got to reposition the camera to do that.
Okay, the northeast corner of the building. The second floor is the courtroom. First floor and basement are the Register of Wills offices and storage area.
Let's walk over that way.
Okay.
This is a beautiful courthouse.
This is a gorgeous courthouse.
Tell me about this plaque here.
Let me jump to the other one first.
Okay.
The other plaque is the plaque or cornerstone for the original building, which was built in 1784. Over the 100 years, the building either had some damage, some fire, I'm not sure exactly what, but it was reconstructed in 1898, and it is the current courthouse now. The second floor up is the courtroom for the Orphans Court.
That's over there.
Next wing down, yes. And the lower floor is the Register of Wills office.
Deputy, why do we have such tight security in our courthouse?
Until we had this set up in place, we were the only courthouse in the state of Maryland without a similar setup. So we had to do everything by hand, which wasn't near as efficient as what we have set up here.
Right.
And it's a preventative measure, as you might guess. We haven't caught, fortunately, we haven't caught anything like weapons, but
Keep cell phones and all out of the courtroom.
yeah, cell phones are a big issue. By the time people see this set up, if they have any second thoughts about trying to get a weapon in,
Right.
they're going to think twice about it.
You're also security for all the courtrooms, too. So
Yes, sir.
You're not the only secure person. I've seen as many as 3 deputies here at a time, right?
Correct, 3 or 4, yes. Right now, we have 4 on staff. We also, in addition to manning the security station, there's a deputy, at least one deputy in every courtroom that is in progress. And there are days when we have 3 and 4.
Now, if a person comes in here with a cell phone and they've parked half a mile away,
Well, that policy has recently changed in the sense that up until January 1st, cell phones were not allowed. We received a directive from Annapolis to allow cell phones in our courtrooms so long as they're turned off.
okay, so you don't have to make people walk back to their cars anymore.
No.
Oh,
So
that's
long as
good.
they're turned off, and we haven't had too much of difficulty with that so far. And I think people appreciate it.
Yeah.
Yeah, great. Well, thanks for doing a good job.
You're quite welcome.
Appreciate it.
Yep.
This is the Orphans Court courtroom.
Well, that's impressive.
Little history. Prior to about 8 years ago, the Orphans Court did not have a courtroom. We did our job in the circuit court, the district court, the county council office rooms, or any other room that was vacant at the time we had court. And it was about 8 years ago that Alice Anderson, the Register of Wills, and Chief Judge Don James requisitioned this space on the basement, first and second floor of the northeast part of the building, and got with the county council and the county planners and developed the courtroom. That included designing the bench, the bookshelves. We had several law firms that were closing practice at the time, and they donated their law books. We have behind us from 1853 to current case law, Maryland reports as to cases that have been decided. We have Mid-Atlantic books which tell us the Middle Atlantic states, and we also have Attorney General's opinions that we can reference. In addition, we've gone to computers, obviously, and technology, and in fact have LexisNexis, which is a research vehicle on the internet that gives you all these law cases also. One of the nice things, in addition to what Chief Judge James and Alice Anderson did in getting us this permanent residence, was that her staff and I worked with county council and particularly Tommy Duncan, and we had a cassette system for recording, and they were half-hour tapes, so we'd have to stop a hearing and stop testimony just to change the tapes so that we could get it all recorded. We managed to get with the state and the county and the electronic people and have a system very close to what the circuit court has now, and it's all digital, so we're first class on our technology now.
Well, it's an impressive courtroom. Tell me now the process that anybody who does not have a will, what would they would go through?
Okay. First of all, let's make it like a railroad track. There are 2 avenues to come into probate or wills or non-wills. One is administrative probate, one is judicial probate. Administrative probate goes through the office of the Register of Wills. A person comes in with a will, they file it, there is a PR usually spelled out in the will.
What is a PR?
PR is a personal representative.
Okay.
Or executor of the estate, that the decedent or the person that died wanted to handle their affairs. That goes to the Register of Wills. Letters of administration are issued.
Let me just stop you there. So anybody, they don't necessarily have to have a lawyer. It's probably a good idea to have a lawyer, but if they don't, they could either get something on the internet or they could write on a plain piece of paper their will.
That's correct.
And tell me, what makes that legal?
Okay, first what makes it legal is it can be off a computer, it can be with an attorney, or it can be a handwritten will. The most important thing is the attestation on the will, which says that this person is of sound mind, that they know what they're doing, and that they have two witnesses that have witnessed them signing the will and are willing to testify under oath that they were of sound mind to the best of their knowledge. That will come in to administrative probate. Letters of administration will be issued, which allows that person, that personal representative, to gather together the assets and file an inventory with the Register of Wills. That inventory is an inventory of all the assets. Once that is accumulated and a list of interested parties, heirs, claimants, are developed, then an accounting is set forward. That accounting gives all the assets and all the liabilities to the estate. That is reviewed by the court periodically, because there may be 6 or 7 accountings. Sometimes it can be done with one accounting. Once all that accounting, and there have been never an issue raised with any of that, gets to its final stage, it comes to the court. The court issues an order that the account is closed and the monies can be dispersed to creditors or the heirs through distribution.
And how long does that process take?
That can take anywhere from 3 months to 9 months. The other side of the track is judicial probate. That is if there is no will, or there is a will, but somebody contests something with the will. The fact that they don't think the PR is the right person, or that there's a claim that has been disallowed they think should be allowed. Every time a disagreement comes up, it's referred to the court, a hearing is held. Again, as you stated, people are not required to have attorneys. We advise them it's in their better half if they do have an attorney, but we will guide them through the process if they do not have an attorney. It is the people's court. They can represent themselves.
Okay.
The person who is challenging is called a petitioner.
Right.
And that petitioner sits on this side.
Correct.
The respondent or the PR sits on that side unless the PR is challenging something. The judges sit up here. Testimony is given in the witness chair here with the clerk, deputy clerk recording the whole ceremony.
And swearing that person in.
And swearing that person in.
This is a real court.
This is a real court. It is a court of limited jurisdiction. We deal only with estates and trusts, probate section of the Judicial Code. We have all the rights and powers of every judge in the state of Maryland, including bench warrants, fines, sanctions. We very seldom ever have to use it because it's not the kind of court where you have those kind of issues. But it is a full-blown court with limited jurisdiction.
Now, since I've been on the court for 6 months, I've seen some very interesting cases.
Yes.
And one of the things that the person who is making out their will should make very, very careful choice of who that personal representative is going to be, because that personal representative has all the powers. They have the powers to sell the house. They have the powers to disperse monies. And what we've seen oftentimes here is that there is someone, an interested party, who will challenge the personal representative.
Correct.
By saying they're not handling things properly. And in that case,
and that forces a hearing.
Right.
In front of the judges. And in those particular cases, even if the court finishes the whole process, there is an appeals process afterwards. If it's a issue of fact where one of the respondents feels that the court made an error in its judgment of fact, it is referred over to the circuit court on appeal as a de novo or as a brand new trial, all new testimony with or without a jury. If it's an issue of law, it is referred up to the Court of Special Appeals, where they deal only on issues of law, where there's a question as to whether the law was interpreted properly.
Now, in your
and in those cases, either case, it is referred back to our court at final disposition.
in your 5 years here, how many cases have been appealed, and how many have won?
We have had approximately 7 in my 5 years, and nobody has won. It's been remanded back to us to continue what we were doing.
Oh,
So we have a good
congratulations.
record.
You do. You do.
So, judicial probate is whenever there's an issue, whenever there's a dispute, the judges hear the facts that are presented and the law that's presented with that. We do our own research in the law books and on the computer as to what current law is, what current opinions from the Court of Special Appeals are, and make our decisions. And when we make our decisions, we not only issue an order, but we issue an opinion, a written opinion which tells both sides, the petitioner and the respondent, why we made our decision. It's composed of the issues, the facts, the law, and then our opinion.
Now, I've noticed in cases that we've heard here that we have family members, cousins or sisters or brothers that come in and fill this courtroom, and they're angry. And they're angry about stuff.
Yeah.
And once the court finishes all of the interviews, I've noticed that the people kind of go out understanding how it works,
Well,
understanding why things happen.
We try to explain the process as we go along, and Judge James does a great job, as well as both yourself and myself, in trying to get people to feel comfortable, to release their hostilities and get a better understanding of what the process is and what the outcomes are going to be.
Now, how does a layperson become a judge? Now, I know the answer to that, but I'll let you.
You know the answer to that. As the constitutional amendment of 1851 stated, they have to run for election every 4 years in each jurisdiction, and the top 3 vote getters are elected to the bench. And when 4 years are up, you got to run again.
Now, it's basically a community service job. The pay here is
Minuscule.
minuscule.
But you have to have a love and a dedication for what you're doing.
Correct.
And I've enjoyed the last 5 years on the bench and look forward to many years ahead.
Well, I know once I was elected, I was required to go what is called baby judge school.
That's correct. We have continuing education requirements.
Right.
All new judges, whether it's Orphans Court, Circuit Court, District Court, all have to go to baby judges school. And that baby judges school is a 2-day session which trains a judge on court management, how to run a courtroom. We have continuing education requirements, all judges, 2 days a year, which gets you into the details of evidence, hearsay, all the complexities of the law. And we're required to do that every year.
I know in my baby judge school, there were 17 judges, district court judges, appeals court judges, that spoke on 17 different subjects. So
Yes.
It was quite intense.
Quite intense. It's a strenuous 2-day session. And likewise, as I said, you can spread the other continuing ed out over a year and do a day or a half day here or there. But you are under mandate, under the judicial system, to get those continuing ed credits every year.
Now, tell me an interesting story. What's one of your most interesting cases?
There are a lot of interesting cases. I think probably one of the most challenging, we had a case where an individual was a native of a foreign country, got married, wrote a will, and that...
Saudi Arabia.
Actually, we don't want to get into the countries, but,
Okay.
Wrote a will in another country, which we were not able initially to determine whether it was in the embassy of his national country or whether it was on the foreign country's soil. So we had to see who had jurisdiction. While we were going through that, we found out that if you get divorced in England, and that was his home country, if you get divorced, the will is null and void, and there is no will. He died in this country, in this county, and therefore died without a will because the will was null and void in the country he initially did it. So we didn't have to really worry about where it was signed, actually, whether it was in the embassy of his natural country or in the country where he was working. So that's challenging, and it takes a lot of homework to get into that information. We have had cases that are funny, where a decedent or a deceased person wanted to get even with their children, and one children liked one home, one liked the other, so they switched them on them and made them live in the home they didn't like. We have had...
That's not funny to them, though.
No. We have had statements that, be careful how you spend it because I'll be watching over you, written right into the will.
I saw one of those.
And we have had
I'll be watching you from somewhere,
Yes.
it said.
And we have had families who've been in here fighting over assets of an estate that was insolvent, had no money. So there were no assets to fight over, but they were fighting over them anyhow.
I remember that case.
So
They were fighting over 6 guns.
Yes, Very interesting cases. One of the key things that many people don't realize is outside the courtroom, the state of Maryland has what is referred to as MAJOC, or the Maryland Association of Orphans Court Judges, which is an association of all the Orphans Court judges in the state of Maryland. And they deal with issues that come up in the courtroom as a networking thing, talking among themselves. They have a board of directors, which I am just getting off of the board of directors of that association. And we've had great representation from Talbot County. Judge James has been on there. Judge Moore, when he was chief judge of the court, Norman Moore, was on that association. There are other activities statewide too. Judge Robert Bell, who is the chief judge of the state of Maryland, appoints a conference of Orphans Court judges, which refers to him issues of law and issues that may go in front of the legislature as far as changing the law, as far as it deals with estates and trust. And I've been fortunate enough, as Judge James has, to serve on that, and we are looking to be reelected to that this year for another 2-year term. So we are contributing statewide and getting a lot of messages from other judges around the state.
That's good. And where do you go for help if you get stumped in a case?
We have an Attorney General representative from the Attorney General's office who we can call and run by thoughts, ideas, and of course we talk with our other judges.
Well, thank you very much. I think you've enlightened a lot of people.
Welcome to the court.
Well,
we enjoy having you in there.
Thank you. I've enjoyed it.
Good.
This is Will Howard signing out.